Mrs. Conger for rebuttal purposes.
Okay, Ms. Conger. Hello, you're still under oath.
Yes, sir.
Mr. Weiser, go ahead.
Thank you, Your Honor. Ms. Conger, I'm going to follow up on some issues that have been raised during the course of trial today. One question is there any occasion that your husband, Glenn, has come over to make repairs on a water heater?
The only time that we had an issue with our water heater was in December of last year.
And was that before the Child Protective Order proceeding?
It was after. Are you talking about the? Oh, sorry. Yes, but it was before the Child Protective hearing in February.
So at any point since February of this year, when you had that trial in juvenile court, has Glenn ever come over to have anything to do with a water heater at your house?
Not after. Just in December last year.
Is there any occasion that he's come over to do any work regarding a car battery?
At the end of July, I was having an issue getting a battery out of my daughter's car because we were working on getting her permit, so we were getting her car back up and going since it's been sitting.
And correct me if I'm wrong, was that after the Child Protective Order had expired?
Yes, sir.
Is there a reason you didn't mention that earlier today?
Because to tell you the truth, this whole month has been kind of a blur, and I'm trying to make sure I put everything up honestly to the best of my knowledge. A lot of it just kind of like I spaced out, unfortunately, and I do apologize that I didn't recall that.
Well, to confirm, so we've talked about there was the occasion back in March at the diner, this car battery in July. Now that you've had more time to gather your thoughts and recall, is there any other occasion since February of this year that Glenn has come over and had any contact with your children?
Not coming over, no. I do believe he helped with the math test. And the end of August, a week ago, maybe. But that was over the phone because I'm not math. I don't get math, especially.
That was over the phone, you said?
Yeah, that was over the phone.
And how do you know this?
Because I was right there.
Have there been any other occasions since February of this year the children have had any telephone, Zoom, Skype, any type of virtual contact with Mr. Conger?
Not that I can recall of.
I want to switch gears a bit, Ms. Conger. I want to talk a bit about your relationship with the children. In your own words, how would you describe that?
Very close. We are very, very close. We try to do everything together. They've kind of separated a little bit because of their ages. They kind of want to do things on their own. I'm having a little hard time doing it, but we love our outings together. We like going on drives, out to dinner. They're very open with me about any relationships they've had, any troubles they've had during school. They're very open and we're very close.
How are the kids doing in school?
Really good, actually. I'm really proud of them. Alyssa only has a C, right, 1C, and she's already planning on getting it up. She's uber excited about her program next semester. She gets to start working on her nursing degree. My son is actually doing pretty dang good so far this year. He actually has A's and B's, which I'm uber proud of because last year he was struggling. So I'm really hoping he can keep that up this year.
Ms. Conger, just so we have a clean record, I noticed you've used the word Uber sometimes, which I think is the German word for over or above. I assume that means good.
I'm very, very happy that I'm very proud of where they're at. Sorry.
Thank you. Just want to make sure we know what the slang term means since you've used it a couple times.
Okay, sorry.
And when you mentioned that your daughter only had one C that she's working on, what are the rest of her grades?
A's and B's. She loves having higher grades. She hates it when it's a low B. And that was her own thing that she always has strived for. I'm just happy that she's passing. Same with my son. I'm happy that they pass, and I'm proud with it, whatever they choose, as long as they're passing. So my standards is preferably a C or better. But Alyssa's like, I'm going above that, and I'm going to try for A's and high B's.
Tell me about their friends, if any, at school.
My daughter has one really good friend, and then a few other friends, but the one friend she's with all the time. We do bingo with her, with food, serving food. She's gone on a couple of our family outings up in the mountains, and she's never been. We've taken her tubing, that she's never been. My son is still kind of finding his place, because he was in a smaller class environment last year because he was struggling in middle school with his peers. A lot of bullying. That's why I switched him over to Doll. So now that he's in high school, I'm waiting to see. I'm hoping he finds a really good friend, to start seeing more involvement with friends.
What about friends in the neighborhood?
We don't really have anybody close to us, family-wise, that are his age.
Well, besides family, I mean, basically, what does he do at this time?
PlayStation a lot. Sometimes he'll ride four-wheelers. He has a truck he needs to work on so that when he gets to start driving, he has a truck to use. But a lot of it just ends up being on the PlayStation.
So with your daughter, I mean, with any time you have kids, they get older before you know it. What are her plans for the future?
Being a nurse. That is like her big thing right now. She talked about, or we've talked about doing traveling nursing. That way she can go see the world. But now she's kind of thinking more of being, I think the last time we talked was more being a pediatric nurse. So I'm not sure exactly. She still has a lot of things to think about, like nursing wise. But she just is ready to be in her class at the VOTEC, which is our technical college. I still call it the VOTEC, but it's the Colorado Rockies Technical College of Montrose and Delta. And they get to join that through their high school.
So she's actually doing some classes at this local community school as well as the high school work?
She will start that next semester.
I take it something she's looking forward to.
She is super excited about it. She is doing a class right now where it's sports medicine, and she comes home and really excited about learning the bone structure of people right now. And she's like, do you know what this bone's called? Or like, what is this bone called right here? Or she's like, do you know what this bone's called? And I'm like, I can't remember what that one's called. So she gets off and she goes off on nursing a lot.
So are the kids involved in any extracurriculars beyond what you've described already?
My son is in JROTC, which is ROTC. It's a military base through the school. He's really enjoying that so far. Alyssa is trying to get into HASA, which is a nursing-based environment where she'll get to meet other girls that want to be in nursing. And she's also been asked if she wants to start doing speech, which is a speech and debate. So she can go do, because she can argue really good right now. And she really makes her points valid.
So with your son, is he contemplating becoming a military officer one day?
That's still way up in the air. He's still unsure what he wants to do. I'm trying to get him to use his hands more. So I'm trying to get him outside more. He does enjoy hunting. So that's been a fun thing. We do have tags to go get deer and elk this year, so we're uber excited about that.
Let me switch gears and talk about the kids' relationship with Glenn Conger, their stepfather. In your own words, how would you describe that relationship?
Like a father. He's taught him how to ride he's taught James how to ride a motorcycle. They rebuilt the motorcycle that he has. It wasn't running when we got it. It's running now, and that was both of them working on it. He's gotten us where we can go see more of the world. Never had that opportunity before, but just like our father, he's only ever there to help and teach him more about what's going on.
So, before the disruptions that happened after the Child Protective Order proceedings, what kind of family activities were you doing with Glenn and the kids?
We were hunting. We would go fishing, boating, four-wheeling. We would go rock crawling with his Jeep. Just outdoors. We were outdoors a lot, and we did a lot outside. And then once all this happened, we kind of bottled up and in the house and really haven't seen a lot until San Diego.
Would you like to see the relationship with Glenn and the kids go back to what it was before?
I would love that because the kids love him very, very much. And they want to learn more about being outside. They want to learn more about hunting. They want to just be more hands-on with the world instead of just being stuck at home watching the computers.
And I recall back at the juvenile court trial, there was some talk about a latch to the bathroom in your house having some issues. Do you recall that testimony?
I do.
So how is that an ongoing problem?
No, it's not. The lock has always worked. I don't know why they've said that the lock did not work, but I use that restroom here and there. It works every time. I've even tried it on the other side, and it works. There's no issue with the lock or the door.
Has there been a time in the past where the latch had issues?
Yes, about 5 or 6 years ago, we did live in a house that it was an old house, and it was an old latch, and it did not work. And sometimes even if the door was shut all the way, it would pop open, and I didn't know how to fix that. I've learned how to, and I haven't had any issues with any of the lock in this house that I'm in right now.
Do the kids always remember to close and lock the bathroom door when they're doing their business inside?
No, unfortunately. There's been times where I've come up behind them and shut the door.
I want to switch gears, Miss Conger, and talk about the children's relationship with their dad, Mr. Potter. In your own words, how would you describe that relationship?
Not very well, not good. I know before I even, the way that they were before I even got with Glenn, James did not want to go when I lived in Hotchkiss a few years ago, before I even met with Glenn. He didn't want to go to his dad's, and I recall that James was in a panic attack, and I had to run from my job at Ace Hardware, which was a couple blocks, and I didn't drive my vehicle that day. I had to run to the house because my son was having a panic attack because his dad was yelling at him.
How do you know that his dad was yelling at him?
I could hear it through the phone.
Well, what was his dad saying that was...
You need to get into this car now, or else I'm going to hit you, or I don't remember. I can't recall exactly what he was saying. I just heard him in the background. You need to get in this car now. It's time to go. And like screaming at him.
Was this unusual behavior from Phillip?
I used to see it all the time when I was married with him because he would do that to me. That was the first time I heard it with the kids.
How did your son react after that call ended?
He shut down. He shut down. He couldn't do anything for quite a few hours. I had to, call back into work because I was supposed to be at work and saying, I can't come in. My son needs me. And I had to just sit there and hold him and rock him. He was really upset that day.
Has this happened on other occasions with the kiddos?
Not so much after we got with Glenn, because the kids were it was hard to get them to go with their dad. Alyssa just started saying, I just can't see my brother that way again.
Did any of this ever happen between Alyssa and her father?
Not that I'm aware of, that I can think of. I just know that she only went to help her brother. I know I didn't know until recently that she wasn't wasn't comfortable at his house.
Have there been any periods of time that Mr. Potter was not exercising his parent time with the children?
Yeah, he texted me asking me if Glenn wanted to adopt Alyssa and James. And that threw me for a loop because I know he's always tried to get me on anything and everything. So I said, what? I'm confused. And he's like, seriously, I'm tired of fighting with them. I don't want to deal with this anymore. I'll give up all my rights.
When did that conversation take place?
When was that?
Objection. This is not rebuttal. This has all already been discussed.
Sustained.
I will move on, Your Honor. Any other concerning behavior between Mr. Potter and the children?
Same objection.
I think it also would go to what the children had to say as well as Mr. Potter's own testimony that...
It doesn't actually rebut what the children said, though.
I'm sorry, more than Mr. Potter, I should have said, because he was denying that there was a strain here.
He was denying that there was a strain?
That's my recollection. Unless I misunderstood his testimony.
I recalled that he was saying that there wasn't any restraint. I just know that since all of this, more stuff has come up where they just have told me I don't feel comfortable. And I would tell them, it's his turn. He does love you. It's time to go to see your dad. And then they would still refuse.
Your Honor, I didn't have any further questions than that.
Okay, thank you. Mr. Beach, any cross on any of that?
Just a very few, Your Honor. Back to the water heater, Ms. Conger. You said that happened in December 2023 when Glenn came over to fix the water heater?
Yes.
Alyssa wasn't with you in December 2023, correct? She'd already been removed from your home by then.
She came back at the end of the year.
Was she around when Mr. Conger came there to work on the water heater?
I don't recall.
And when did you live in Hotchkiss?
In 2000 to 2021, or
3 years ago.
Or it could have been 19 to 21.
Okay, 3 to 5
I was there for almost 3 years.
Thanks. Those are all my questions.
Okay, thanks. All right, anything further, Mr. Weiser?
No, Your Honor.
Thank you. Anything further, Mr. Beach?
No, Your Honor, that's all.
All right. Then I will go ahead and let counsel make closing statements if you'd like.
Yes, Your Honor, thank you. Should I go ahead?
Go ahead.
Phillip has brought his motion for temporaries pursuant to Utah Rule of Civil Procedure 106, which allows the court to modify custody and parent time during the pendency of a modification to address an immediate and irreparable harm, provided that the modification serves the best interests of the child. The evidence today demonstrates that there is an immediate and irreparable harm that needs to be addressed. Phillip requests that the harm be addressed through a change in custody. A child protective order was entered against Glenn Conger on February 5th, 2024, after an extensive evidentiary hearing was performed by Judge Evershed. Judge Evershed found that the parties' children, both of them, were being abused or in imminent danger of being abused by Mr. Conger. The child protective order prohibited Mr. Conger from contacting or otherwise communicating with the minor children directly or indirectly. It also required Mr. Conger to stay away from the children's residence. The evidence is that Cassandra was present at the child protective order hearing and heard the allegations. The evidence is that Mr. Conger received the child protective order from his attorney the day that it was entered, and he knew of the child protective order and its prohibitions and knowingly violated the child protective order numerous times. The evidence is that Cassandra also obtained, apparently, a separate restraining order against Mr. Conger in Colorado, which demonstrates that she had concerns about Mr. Conger, concerns she essentially denied having today during her testimony. And the evidence is that Mr. Conger violated that restraining order as well and was arrested for it. There's hardly better evidence that both of the Congers knew of the child protective order and its prohibitions and requirements than Cassandra's own testimony that Mr. Conger has not been allowed to live at the home since entry of the child protective order, and that Mr. Conger accepted that reality. However, even still, the evidence has shown that Cassandra has allowed the children to contact Mr. Conger since entry of the child protective order. Cassandra's testimony today is that she knew as early as the beginning of March 2024 that the child protective order prohibited Mr. Conger from being in contact with the children. And even with that knowledge, she met with the children and Mr. Conger at a diner on March 29th, 2024, and discussed their futures together in front of the children. By Mr. Conger's own admissions today, Mr. Conger violated the child protective order by going to the diner with the children, as well as going over to the children's residence in March, and the evidence has also demonstrated that Cassandra told him that he could come over. Cassandra testified that Mr. Conger never went over to the house while the child protective order was in place, but the evidence has demonstrated otherwise, and this naturally calls into question Cassandra's testimony and credibility. Cassandra has sought to minimize these obvious violations of the child protective order now that there is evidence proving the violations by essentially saying that she didn't see any harm in the encounter because it was in a public place and because she was supervising. But the encounter and also allowing Mr. Conger to come over to the children's residence were still violations of the child protective order, and no real responsibility or accountability for that has been taken. The concern from our perspective, Your Honor, is that if a Utah child protective order and apparently a completely different restraining order sought by Cassandra in Colorado weren't enough to get the Conger's attention about the seriousness of the situation regarding Mr. Conger's contact with these children, it's difficult to imagine that any other court order will. Mr. Conger explained that he was willing to violate the child protective order, and his willingness to do so is startling and troubling. The risk Mr. Conger poses to these children has not been abated since entry of the child protective order. Cassandra has still allowed the contact between Mr. Conger and the children. Both Congers sort of explained, Cassandra has indicated that some family therapy may be in the works, but I think the real question is why that didn't happen immediately and why it still hasn't happened even today. The evidence suggests that the Congers will continue to toe the line as much as possible and that they've stepped well across the line since entry of the child protective order. The evidence is also that there is apparently no divorce between the Congers in the works, which indicates that the risk Mr. Conger poses to the children is going to remain because the Congers' marriage is going to continue. The immediate and irreparable harm to the children is Mr. Conger and Cassandra's willingness to let things slide, to ask forgiveness for allowing contact when she never should have allowed it to begin with. Mr. Conger's risk has not been abated, and according to the evidence today, has not even been hardly addressed in any meaningful or measurable way, particularly concerning Mr. Conger's testimony that contact should be restored between him and the children, and Cassandra's pretty wishy-washy testimony on whether she'll allow him around in the future. In addition, for all the same reasons that there's a risk to these children that has not been abated, it's also in the children's best interest to change custody to Phillip, with Phillip being awarded sole physical custody. That's the best way of abating Mr. Conger's risk to the children. The court should grant Phillip's motion for temporary orders and protect these kids. And on that, we submit.
Thank you. Mr. Weiser, go ahead.
Thank you, Your Honor. Everyone appears to agree the burden is upon Mr. Potter, the petitioner, to prove that there would be immediate and irreparable harm unless the court orders a flip in custody, and he also bears the burden of proving that course of action is in their best interest. The court certainly has judicial notice of the hearings we already had before in the juvenile court. Unfortunately, we don't have the benefit of detailed findings from that court as to the basis decision other than the fact it issued an order, at least as to Mr. Conger. We do know from the statute the standard is either finding that there was an actual act of abuse or that there was a risk of harm at the time. I certainly wish the judge would have clarified which of the two it was, but it doesn't, so we're certainly left to make inference. I would point out, though, I think there is an immense, I would dare say, light years difference between a court making a finding of fact that actual abuse did take place versus a finding that there's a strong concern that maybe it could or might in the future. But I do think the circumstances of this case, in particular the children's own testimony, suggests it was more of a risk concern than an actual finding of actual abuse. Certainly both Glenn as well as the children deny that there was any physical abuse or inappropriate touching. At most, it seems we might have had an accidental touching. Both CPS and law enforcement, I believe, undisputed, they took a look at this situation. They didn't find enough to make any type of supported finding. I know there was an initial removal, and certainly that's what typically happens out of an abundance of caution, but not something that was found supported by them in the end. So since the hearing addressing the issue of is there an ongoing risk of harm or has that been abated, we have the undisputed testimony. My client candidly acknowledged there was this encounter at a diner in March of this year. No real dispute as far as I can tell that it was supervised the entire time. It was a public place. There was no opportunity for any mischief or untoward conduct. Certainly, if I had been involved, I probably would have advised these folks, hey, the protective order is still in effect. Even with supervision, you ought not to be doing this, but it happened. Certainly, it shouldn't have. But at the same time, I think my client testified credibly. She did not have a copy of the juvenile court child protective order against Glenn. She knew in a very abstract sense there was something out there, but the way the juvenile court's e-filing system works, when you have different cases against each parent, one doesn't have access to the file for the other. It wasn't until after the fact that she learned there was that absolute restriction. So I would argue there was no intent to violate. She thought she was operating within the parameters and being reasonable. In hindsight, she was mistaken. We acknowledge that, but there was an intent to say, here, have a date with the kids. I'll go off and do something else. There was appropriate safeguards in place. And most importantly, that hasn't been repeated during the period until that order expired. So that in itself abated any safety risk. Even since then, all contact, very limited at that, between Glenn and Mr. Conger has been supervised and extremely limited. A single isolated supervised contact at a public diner does not rise to the level of immediate and irreparable harm, and there's certainly no credible allegation that kids have been abused or threatened with any abuse since then. So we're basically having a situation of a solution in search of a problem, as the saying goes. Just the same, Ms. Conger does take this seriously. Safety plan is certainly warranted and within the discretion of the court. Certainly when the juvenile court issued the child protective order, by its very nature, this was a temporary order that went away after 150 days. There was an ongoing guidance to Ms. Conger as to what she should do going forward. So her implementing a rule of sight and sound supervision, I believe, was reasonable under the circumstances until we could get further guidance from this court. Mr. Conger is taking the concern seriously. I think both sides have acknowledged that some form of counseling or family therapy would be beneficial. One of the practical challenges we're dealing with is both parties reside in small communities. We don't necessarily have tons of providers with unlimited availability. Ms. Conger is trying to get that arranged. She's been running into some challenges. Mr. Potter reports that he made a proposal, but I'm not really seeing evidence of any follow through on his part, even though he's criticizing Mrs. Conger for not being more diligent. We never had any letter from counsel saying, hey, I propose we use therapist X, Y, and Z. Here's dates that are available. Let's make it happen. It's a two-way street to get this all arranged, and I think both sides, frankly, need to exercise some more diligence there. And also in terms of the best interest factor, which is also something we're required by law to consider, Mr. Potter has not met his burden of proving that a flip in custody right in the middle of the school year would be an improvement for the children's best interest. He doesn't have a strong bond with these kids. In fact, it appears it was so strained that at one point he was contemplating relinquishing his parental rights altogether, which I think speaks volume as to that strain. He has been harsh towards the children, and that's contributed towards the strain on their relationship. It appears what's motivated Mr. Potter now is he's found there's another stepfather figure, that the children have a very strong bond with Mr. Conger. He's done all the things that we would expect a father figure to be doing with these kids, and the kids love him. They've had great times. He's been teaching them valuable life skills, making wonderful family memories. I'm hard-pressed to believe there's not some jealousy going on here, and that may be motivating him to make mountains out of molehills, as the saying goes. We also have evidence from the children that he's been bad-mouthing their mother around them. That is never inappropriate, and that, frankly, is a form of psychological abuse on Mr. Potter's end. There's also concerns that he may be getting pressure from some of his relatives, perhaps the mother-in-law, that he needs to be more involved, and that may be some of the driving force behind his sudden interest. But the totality of the circumstances of this case show that Ms. Conger is taking these concerns seriously. She has been implementing reasonable safeguards to abate any risk of harm since the Child Protective Order proceeding. But at the same time, not going overboard and divorcing Mr. Conger and barring all contact whatsoever when, frankly, the circumstances don't warrant that extreme course of action. I think family therapy is the right answer, not jumping the gun to these other things. And certainly these children, they are rooted in their community. I mean, their daughter in particular, she has a bright future ahead of her, wants to become a nurse. She's taking classes, involved in extracurriculars. She has friendships. All of that would go away if the court ordered some type of flip in custody. That would not be beneficial for this young lady in any way, nor do I believe that would do anything to improve the relationship between her and dad. Frankly, I think it's going to be like pouring gasoline on a fire, given the strain that already exists there. The children have confirmed to the court they prefer to keep the status quo and stay where they're at right now. These are not infants. These are teenagers who are going to be adults soon enough anyways, and by statute, we are required to give additional weight to their preferences. And also, being teenagers, they're not like infants where they're completely at the mercy of whatever caregiver or person they're with. If they are involved in a situation where they feel unsafe, someone's taking advantage of them, whatever, they can get out, they can report to teachers, friends, a whole network of support folks, so that way they're not lingering in an abusive situation, which is all the more reason why we shouldn't do anything drastic with a flip in custody. It's neither necessary nor is it in these children's best interests. So we ask the court to deny the father's motion. I think it would be prudent for the court to order family therapy and give guidelines to make that happen. I would suggest the appointment of a guardian ad litem as well to work with these folks and help them deal with these troubling family issues. but a custody change is a solution in search of a problem. It's an overreach and should not be ordered. Does the court have any questions for me?
I don't. Thank you.
Thank you, sir.
All right. Rule 106 of the Utah Rules of Civil Procedure is the governing rule in this case, and it provides that I may order a temporary modification of custody or parent time to address an immediate and irreparable harm or to ratify changes made by the parties, provided that the modification serves the best interests of the child. So I have two things to look at. One is there an immediate and risk of an immediate or irreparable harm? I think, and the question is, how big is that risk? And then, is the modification that I make serving in the best interests of the children? Judge Evershed, after a hearing, found that there was either an abuse or a danger of abuse, and the testimony from that hearing, which was proffered to me, all relates to sexual behaviors of Mr. Conger. So I don't know exactly what finding Judge Evershed made with regard to whether something happened or was going to happen, but it was clearly related to Mr. Conger's behavior toward Alyssa, and also potentially toward Nicolette, which, Nicolette was a 19-year-old who lived in the home for a couple of months, and perhaps his behavior toward Nicolette was concerning to Judge Evershed as far as would he do those same behaviors toward Alyssa? And then, of course, testimony about cuddling, spooning, and so forth. So the threat that Judge Evershed found was related to improper sexual behavior by Mr. Conger potentially toward Alyssa. The question for me today was, and we had talked about this at the scheduling conference, whether that danger of abuse or danger of abuse constituted an immediate and irreparable harm, and I find that it does. And the question is has it been abated? And that particular risk that Mr. Conger might have an improper touching or improper sexual behavior toward Alyssa has not been abated. It's been abated to the extent that they've been separated, but in the same home, that behavior would continue because Mr. Conger doesn't recognize it as improper behavior, nor does Mrs. Conger recognize it as improper behavior. They see it as one of the statements by a witness in the protective order hearing was that Mrs. Conger would simply tell Mr. Conger, "Don't do that. She doesn't come from a place where that kind of touching is okay." So Ms. Conger doesn't think it's wrong touching. She just warns it. Everybody agrees that that's appropriate. Apparently she does, and apparently he does. And there's been nothing done, no education, no awareness, no study or finding out whether that behavior, to address that behavior. There was some suggestion that maybe this was jealousy. This action was brought by jealousy because Mr. Potter thinks that the kids like the stepdad more or something. I think it's more that he thinks it's troubling that an adult man who is not his daughter's father is spooning with her while they watch movies. we're sort of glancing over what the testimony was from Nicolette. Mr. Conger may think that's okay, but and there are probably others that think that's okay. But I am astounded that anyone would think that for me to spoon with a 16-year-old girl who is or is not my offspring, but especially is not my offspring, is somehow natural and normal. Maybe it is in some society in some period of history, but in our society at this time in history, it is not. Nor is slapping someone who's not your child on the backside in a joking manner, who's a teenage girl, whether she's 19, as was Nicolette, or Alyssa, who was 16. I am not making any judgment about Mr. Conger's intent, because I don't know what his intent was. Maybe what he's doing is purely innocent, which is, I'll allow for that. But his actions, minus intent, would constitute criminal offenses in Utah. I was looking at the lewdness statute. He could, depending on intent, he could be guilty of lewdness, sexual battery, voyeurism, sexual abuse of a minor, and providing alcohol to a minor. Now, I'm not saying he's guilty of those crimes, because all of those are intent crimes. They require that you're doing it for the gratification, sexual gratification of yourself or another on some of those. And he may be completely innocent of any sort of sexual intent. That's possible. But the actual behavior, what he physically did, minus intent, would constitute crimes. That's 5 different crimes, sexual crimes, that he potentially committed, depending on what his intent was. And he doesn't see that as a problem, nor does Ms. Conger, which is concerning to me, which I believe constitutes a threat of immediate and irreparable harm, because he hasn't taken any action to educate himself on this issue, nor does he see the need for it. And so if we were to just move forward without some sort of modification to the custody order, the risk is he would continue to lay his hands on a 16-year-old girl to whom he's not related in a way that's constitutes a crime, depending on the intent level. His lack of insight into the modern world and the behaviors between men and women is sort of surprising. The testimony that he tried to undo Nicolette's bra while she was driving, I mean, that was a junior high trick in the 1980s. I doubt it's a junior high trick nowadays, maybe, but it's probably not. I mean, you probably land yourself with criminal charges if you do that now. But for an adult man to think that somehow you could unlatch the bra of a 19-year-old girl to whom you're not related or not, unless it's your wife, that just shows a significant lack of insight into modern sexual mores. And so he simply doesn't get it. Now, that's giving him the benefit of the doubt, that there's no bad intent, that he's just uneducated and doesn't get it. The other side, potentially, is that he's grooming young women. Now, that would be the opposite side, assuming he's got intent here. And I'm not making that assumption. I'm just saying he's clueless, but what he's doing would constitute crimes depending on his intent. And so that's the risk of the harm. And Ms. Conger doesn't see the risk. And so she wasn't protecting either Nicolette or her daughter except to say, hey, he didn't grow up in a family, or she didn't grow up in a family where having her bra unlatched was okay. And so I think that a modification is in order. Now the question is, what modification ought I make to the custody order? I am not convinced by the evidence that it's in the children's best interest to change custody. The relationship between the children and their father is very strained. And the relationship between the children and their mother is very good. And my concern is that if I flip custody, I'm going to cause really hard feelings and damage the relationship between the children and their father. I also fear that their move at this point in their life as teens, where they have friends and educational opportunities and things in their lives seem to be, they both reported to me that things in their lives were going quite well where they are. I fear that change in custody would not be in their best interest. And so although a modification is in order, I do not find, because of the children's relationships with their respective parents, that a change in custody is in the children's best interests. And so I am going to make a temporary modification to the custody, and that temporary modification is that the children will have no in-person contact, supervised or unsupervised, with Mr. Conger. The reason I'm not allowing supervised contact is because I doubt Ms. Conger's ability to provide constant line of sight, sound contact. I also doubt her willingness, either ability or willingness to do it. She doesn't think that there's a problem here. And I don't think that if Mr. Conger were in the home that she would be that concerned about making sure she was in the room. She's not. She's an unconcerned parent as far as it concerns Mr. Conger. And so I'm just going to order that there be no in-person contact. As far as telephonic contact, electronic contact with the children, I will allow that. He seems to be able to help with schoolwork. And I'm okay if he visits with the children through electronic means, but there will be no in-person contact. That contact should not include any discussions whatsoever of living circumstances, restraining orders, custody or parent time. It should involve things like, how did your day go? Can I help you with this math question? Things like that, normal relationship stuff, but it should not involve any discussions of this case in any way. All right, parent time will continue as it was. There doesn't need to be a modification of child support. Ms. Conger, you should be aware that violation of this temporary order could result in me changing custody. You are not concerned with Mr. Conger, but I am. I think that maybe we're hyper aware as maybe I'm hyper aware as a judge of things because of the things that I see in court in criminal cases. I've heard from victims advocates and domestic violence specialists, but the kinds of things that Mr. Conger was doing with your 15, 16-year-old daughter is potentially grooming. And you ought to be concerned about that. Okay, so that'll be the order. I think I will go ahead and order that the parties participate in family therapy. I am I'm just going to throw a name out there. I have no idea if this person is available on your insurance or not. I know nothing about it. I only throw the name out because when I was a practitioner, there was a person who was in practice in Price, Utah, who was a family therapist who I observed on a couple of occasions, and he was really good, trying to mend relationships between parents and children and parents in high volatility circumstances like this. His name is Bert Bruno, Bruno. He's far away, so this isn't something where you'd be doing this in person. But with the advent of therapy by video, by Zoom, a lot of therapists do their therapy by Zoom. And my understanding of virtual therapy, at least in some trainings that I've been in, is that virtual therapy is as good as in-person therapy. At least with the individual therapy. Whether that's the same for family therapy, I don't know. But as far as individual therapy goes, virtual therapy is as effective as going to someone's office. And so you might want to try and contact Bert Bruno, see if he does family therapy, see if he does it by video, see if he's covered by your insurances. I only say that because I saw him being very effective in some cases. That's a suggestion. But you, of course, get to choose whoever you would like. And I think that it'd be very helpful to the relationship of the parties to engage a professional and help you work through issues with the children and with each other. I think there would be an enhanced understanding of things, and things might go better between the parties and the children going forward. All right. I think that's my order. Are there any questions?
Your Honor, clarification on the family therapy. I'm assuming the expense of that, whatever insurance doesn't cover, would be split like any other child-related expense.
Yes, I'll order that anything that's not covered by the party's insurance should be divided equally.
Thank you. I did not have any other questions.
Okay.
No questions. Thank you, Your Honor.
All right.
Your Honor, would you like a order from today, and if so, who?
Yes, Mr. Beach, will you prepare that order?
Yes, of course, Your Honor.
Okay. All right, that will be it. Thank you very much.
Thank you, Your Honor.
Oh, we lost
Still
Mr.
here.
Beach. That's okay. We lost Mr. Beach, but I already, if both of...
You want me to call him and see if he can return?
No, I was just going to give some advice to the parties, but I'll spare them. Thank you.
Thank you, Your Honor.